Is that 5 minutes, Sheldon?
Yep,
You want to start another file?
I already did.
Oh, awesome. Oh, you're doing it. Okay, good. However, the Supreme Court did find that the process that states were using to convict people and sentence them to death was problematic and was a violation of the Constitution's Equal Protection Clause and the Due Process Clause of the 5th and the 14th Amendments. Why? The reason they said was that there was too much inconsistency, arbitrariness, capriciousness on the part of the state governments and city and local governments when it came to applying the death penalty. For example, in Georgia. In some parts of Georgia, the same person committing the same crime would be more likely to get the death penalty than in other parts of Georgia. Why? Because ultimately, in most states, the death penalty was left up to the discretion of a judge. The judge would decide if a person merited the death penalty. And some judges were more harsh when it came to, you ever heard the term hanging judge? Some judges were hanging judges. They just thought everybody should be executed. And other judges were a little bit more lenient, a little more soft on crime. And in other words, there was no uniform application of the death penalty within a given state. And therefore, clearly, due process was being violated for some people. And so, merely because you lived here as opposed to there, merely because this judge is the one that heard your case instead of this judge. And this was the case all over the country. There was too much discretion and flexibility given to judges to decide who should be executed. And the Supreme Court said this was problematic. And so they said the states had to stop executions immediately. And they had to go back and fix their death penalty laws if they wanted to continue executions. And they had to fix those laws to make them more just, more uniform, more standardized across the state, so that it would no longer depend on which judge you got whether or not you were executed, but rather on a rigorous application of some sort of standard system of justice. So, in the aftermath of Furman, many states began, those states that wanted to continue with the death penalty, they began to pass new laws, changes to the death penalty in those states. I'm going to walk you through 3 or 4 examples of fixes that state governments employed in order to be able to continue using or applying the death penalty. One of those fixes is known as a guided discretion law. In a guided discretion law, the judges and juries are given a standard set of factors to consider before deciding or while deciding on whether or not to apply the death penalty. These sentencing guidelines are the same in every part of the state, in every court, in every courtroom, and used by every judge and every jury. And typically, this is hard to talk about in general because different states have different versions of guided discretion law. But typically, in a guided discretion law, juries and judges are asked to look at 2 things. One is a list of aggravating, or let's talk about mitigating factors since it's there first. A list of mitigating factors. Mitigating factors are things that make the crime in question less heinous, less horrible. Things like a woman killed her husband, but her husband had been abusing her for many years. Or a man killed his friend, but they were both really drunk and didn't mean it. He didn't, and he's being remorseful. Or one person killed another person, but the person who did the killing was addicted to drugs and had been for a long time. These are examples of factors that make the crime certainly not better, but less heinous, less horrible. And in a guided discretion law, or a guided discretion state, judges and juries would have a list of possible mitigating factors. They wouldn't just be